Welcome back. I'm Ladan Korhani. So the first two segments I spoke about how to bring an application to court and how to respond. So now you're at a stage where you're attending the first appearance court. The first appearance court is in front of a court. There's no judge. Nothing is on record. It's mainly for the court clerk to ensure that all the documents have been signed and filed. So the application obviously was issued. Um, it was served, and the respondent served and filed. It depends on the jurisdiction, but in most jurisdictions, if something is missing and the respondent, let's say, did not serve and file, the court hearing does not progress. It does not go to the next level, which would be before a judge. So usually it's extended, the first appearance court, if the respondent is able to get consent to late file. If not, I explained they have to ask the court for permission to extend the late filing, and the first appearance is adjourned. So let's assume everything is filed, and now we need a court hearing for a case conference hearing. What's a case conference? A case conference is before the judge. However, it's really the purpose of it is to resolve the issue on consent. What does that mean on consent? It means by agreement. So you attend the case conference hearing. You make your submissions that day. You need to speak with the judge. The judge may give you some recommendation and assist you in trying to resolve your issues, your claims. And if you do, then that's great. If not, then you progress to the next stage. But if you are going to a case conference hearing, you need to file documents again. It would be it's called the case conference brief. You can find it online, or you can go to the courthouse. It's 17A, Form 17A. In that form, it's asking you very specific questions. You answer that, but mostly you get to the point where it's asking you what the issues are. The issues are whatever you want the issues to be on that day. Is it parenting? Are you not getting parenting time? Are you not getting the primary care that you want? Are you not getting the child support or spousal support? Are there property issues? So whatever the issues are, you need to write it down for the judge. There are limitations in terms of how many pages you can write. So check with the jurisdiction, because again, they're all different. So I can't really tell you like what it is, whether it's 8 pages, 9 pages, 10 pages. So make sure you check that. But just know that this is the document that the judge is going to review. The judge is not going to review the application or the respondent. I mean, they may, but mostly they don't. They're not obligated to. The application and the response is really just mainly for trial purposes. So these case conferences, you want to put in what the issues are. What has happened since first appearance until the case conference? What's going on? So if you do not serve and file this document, if you're the applicant, at least 6 business days prior, and the respondent at least 4 business days prior, your matter may not be heard. And there may be a cost consequence, meaning if the applicant came prepared with a lawyer or even without a lawyer, and the respondent did not serve and file a case conference brief, and it was pretty much a waste of that day, the applicant can ask for costs. So it's really important to ensure that you are filing the documents. Okay. The other very important document that's required is the confirmation. It's the 17F. It's 2 pages. It's saying is that you conferred with the other party that the matter is going ahead. Okay. And whether you called them, whether you text them, whether you sent them an email, that document needs to be served and filed 3 business days by 2 p.m. ahead of the case conference brief, but I always recommend just serve and file it at the same time you're doing the brief. It just makes it easier. So now that you have filed your materials and you attend court, what's going to happen? Like I said, it's all about negotiations. If you qualify for duty counsel will be present on that day, and you can ask the court clerk to assign you to a duty counsel. If not, then you will have to negotiate with the other party and see if you can come up with some minutes of settlement, whether it's temporary or final. If you can't come up with anything, then it goes to the next stage, which is a settlement conference. A settlement conference is very, very much similar to a case conference, with the exception that you're including an offer to settle. An offer to settle is you're pretty much telling the other party, this is what I want to settle. And you have to also complete a brief. So the offer to settle is part of that brief, and that's a 17C. So make sure you complete that. It's very similar. As I said, the only difference is really the offer to settle. And again, the times are the same. Applicant 6 business days prior, and respondent 4 business days prior, and you still need to do a confirmation as well, the 17F. And after that, it goes to a trial scheduling conference. So it's getting really close to trial. And the trial scheduling conference is really just about making the arrangements in terms of serving and filing documents prior to a trial. So you get an endorsement form that you need to fill out along with the judge. You fill out, it's not easy in terms of knowing what you need to do to prep for trial if you're doing it yourself. So that's where it's getting very serious and very close to trial. That's called a trial scheduling conference. There's no duty counsel there, and I should probably mention that there's no duty counsel at the settlement conference either. After that, it goes to a trial management conference. The trial management conference is pretty much you have done mostly your trial prep. Sometimes you have done it, and sometimes you haven't, because the trial management conference could be ahead of that. It's pretty much your last chance at trying to settle. If you can't settle at the trial management conference, it goes straight to a trial, and you have, hopefully you've done your prep, and the prep is going to be based on the trial scheduling conference endorsement that I just mentioned. And that's it. And then you're at a trial. And now the judge makes the decision on what's going to happen with any of these claims. Family court really encourages settlement, because just know that when you hit the stage of a trial, and if you lose, you could be subject to a significant amount of cost. The one I actually just saw not too long ago, he lost the trial, and it was around $300 and some thousand that he has to pay for the trial. So just know there's a lot of opportunities to settle, and a majority of family court cases do settle. But this is really those are the stages of family court. Thank you, and until next time.